this affect employers and individuals returning to work and school. We've been able to put on this programming and other efforts because of the support of our sponsors, including Connecticut Natural Gas, Southern Connecticut Gas, and UI. And also we stream with several other chambers across the region: Central Connecticut Chamber of Commerce, Quinnipiac Chamber of Commerce, Madison, Milford, and the Bridgeport Regional Business Council. Thank you to our investors who continue to help us keep this chamber moving forward. We appreciate all of their support. It is so critical as we've gone through the pandemic here. Well, we're excited to bring you this. This is a HR Council with the Chamber of Commerce presented by Carmody, and also our nonprofit resource council presented by Mosaic. Both of those councils have come together to bring you this programming. Now, if you've joined us during the summer, you know that we've taken the morning mingle and turned it into councils and conversation. And in this format, unlike our other webinars that we usually put on, this is a meeting so that it gives everyone a chance to see each other. And then at the end of our panel, we do have breakout rooms, and those are going to occur at approximately 8:45. So a good chance to network, albeit virtually, after we go through the programming that we have for you today. And we do have a really, maybe exciting is the wrong word when you get into talking about HR, but very important topics for you today. And I'm pleased to be joined by Sarah Healy, a partner with Carmody, Torrance, Sandick, and Hennessy, Alan Bowie, an associate at Carmody, and Jessica Burdacki, HR and benefits specialist at Hobson Motzer. I'm going to hand things over to Sarah, who's going to navigate the controls on a PowerPoint that we're going to work off of. But this is an interactive conversation, so please feel free to jump in at any time if you have questions. We're going to be going back and forth between Alan and Sarah, and then also Jessica's going to be adding some of the experiences that she sees at their organization as we go through some of these key issues. So thank you again for joining us. Please ask questions at any point and stick around with us so that we can have you for our breakout rooms at 8:45.
Good morning, everyone. Thank you, Garrett, for that warm welcome. I'm just going to get started because we do have a bit of an ambitious agenda here. And as Garrett said, Alan and I are really excited to be here today, and we're just going to kind of take turns going through some of what we've put forward on this agenda, along with Jessica, who I'm sure she can provide some of her own practical experiences as well to some of these issues. So what we wanted to touch upon today to begin with, sort of at a high level, are some updates to the Families First Coronavirus Response Act. There's been some recent DOL revisions to the regulations, so those we want to go over. We want to talk about some of the executive orders that have been coming out from the governor's office, and then some updates that are unrelated to COVID, but just as important for us to talk about today. So with that, I'm going to start with the Families First Coronavirus Response Act. And just to give a little bit of background, I'm sure many of you are familiar with this, but with everything changing constantly, I think it helps to just kind of review some basic facts about this law. It went into effect on April 1st, and it's going to expire as of right now, December 31st of this year. And I say as of now, we just never know if something's going to get extended, you know, with everything going on, whether Congress is going to come back and say that they want to extend this law. But right now it expires on December 31st. As you probably all know, it created both the Emergency Paid Sick Leave Act and the Emergency Family Medical Leave Expansion Act. And under the Paid Sick Leave Act, you get up to 80 hours of paid sick leave for certain qualifying reasons. And under the Emergency FMLA Act, employees can get up to 12 weeks of leave for childcare related reasons. And I'll go over those briefly in the next slide. It does provide 100% employer tax credit. So all the money that you have to pay out for this paid leave, you get back in terms of a tax credit. And you are required to extend this paid leave to your employees if you are an employer with fewer than 500 employees. There are very limited exceptions for businesses with fewer than 50 employees for child care related leave only. So that's just a very limited exemption that exists. Now, as you also probably all know, just some more background, if you are an employer with 500 or fewer employees, you are required to give an employee who is unable to work or telework paid leave for any of these 6 qualifying reasons. And the first 4 and the 6 are all under the Emergency Paid Sick Leave Act, which I put up here as EPSL. That's just how we refer to it. And just again, some of these reasons are if you have to quarantine because of you've been diagnosed with COVID, you've received a local quarantine or isolation order related to COVID, you're experiencing COVID symptoms and you're seeking a medical diagnosis, an employee can get those up to 80 hours of paid sick time. The one that I think is probably the most complicated for employers and the most challenging is number 5, which is under both the Paid Sick Leave Act and the Emergency Family Medical Leave Act. And that's where you have to give paid leave to an employee who's has a child that they're caring for, whose school or place of care is closed, or the child care provider is unavailable for reasons related to COVID. And I'm sure, and Jessica, I'm probably ask you to talk about this a little bit later as we get more into this area, but I think that this is the one where we're seeing more and more requests for time off for paid leave from employees, because they just, with the way our schools are right now, with the hybrid school systems and the closures for quarantine orders, we're seeing a lot of parents needing, or guardians needing time off to care for children. So with that kind of basic background, and again, that was a very high level overview, I wanted to go over kind of what happened in early August. So there was a New York federal court district that kind of surprisingly invalidated some of the regulations that DOL had promulgated early in the spring. And one of the ones to me that was most surprising was the court found invalid the requirement that an employer must actually have work available for an employee before the employee can take paid leave. And when you read this decision, it really left open that if an employer had shut down its business temporarily or had furloughed an employee, they may still have to give that employee paid leave if they fell under one of these qualifying reasons. And that was very surprising. So that was where we were kind of in early August. This federal district court also said that the definition of healthcare provider was way too broad. You may recall that the Department of Labor said that employers who employ certain healthcare providers in healthcare facilities could exempt them from the paid leave. And it had quite a broad definition of what a healthcare provider was. And the court here said that was just way too broad. The court also invalidated the requirement that an employee must get employer consent for intermittent leave under this act. And it invalidated the requirement that documentation be provided before taking leave to support the leave. Now, this happened on August 3rd. No one was really sure how much of an impact this had, whether it applied to across the nation or just New York. We were waiting for the Department of Labor to give us some guidance as to what they were going to do. And they finally did that. Late September 11th, they issued revised regulations that went into effect on September 16th, so just last week. And they did 4 basic things, which I'm just going to go over briefly. The first thing it did, which I think is a good thing, is it reaffirmed that both the paid sick leave and the FMLA may be taken only if the employer has work available from which an employee can take leave. So if you've had to temporarily shut down due to an isolation or quarantine order, or because you've had to furlough employees for temporarily, you don't have work available. So therefore, if that employee gets COVID-19, you don't have to give them paid leave because there's no work available. So I think that was good because we were concerned based on that court decision that may not be the case. I want to point out though, that this interpretation, the DOL makes clear, does not permit an employer to avoid granting leave simply by trying to claim there's a lack of work or finding a way to create a lack of work. Remember that there is an anti-discrimination, anti-retaliation provision in this statute for employees that can seek remedy if they believe they've been discriminated against or retaliated against for taking leave or attempting to take leave. So you want to keep that in mind too. Next, and this is a real big one. Number two, the Department of Labor confirmed again that intermittent leave under the Family First Coronavirus Act can only be taken with employer approval, with consent. So you may recall that you cannot take intermittent leave if you're working at a work site. You can't come into work intermittently if you've been diagnosed with COVID-19, for example, or you're caring for someone with COVID-19. The court says you can't take intermittent leave for that. The Department of Labor said you can't take intermittent leave for that reason. You can, with employer consent, possibly take intermittent leave if you're teleworking. Now, the really big one, the big question though, comes again with this childcare related leave, right? So employees who want to take paid leave because they have a child whose school is either in a hybrid a school session or has closed down due to a quarantine order or is unavailable, that employee can still go to work because they're not sick, they're not about to spread COVID-19, that there's no risk of that, so they can go to work. But then the question becomes, can they take this leave intermittently? And the Department of Labor first said, well, you need employer approval to take, you do need employer approval to take leave intermittently. However, where an employee has a child that's on, say, one of those hybrid schedules where you're going to school every Monday, Wednesday, and Friday, but you're working their schooling remotely on Tuesday and Thursday, that's technically not a request for an intermittent leave because the school is closing on Tuesday and reopening on Wednesday, closing on Thursday and reopening on Friday. So the long of the short of it is, if an employee has a child care issue due to a rotating schedule, they don't need your consent to take intermittent leave from you. So they basically can request it and you have to grant that if they meet the supporting documentation standards. And with that, Jessica, I thought I'd maybe open it up to you since we're on this piece, and maybe you can speak more to what you're seeing and if you have any advice for employers that are getting these types of requests and how you're addressing them.
Absolutely. You touched on a lot of stuff, but the biggest, our biggest issue here is finding that balance between being sensitive to an employee situation and also being able to run a business. So like you said, there's a lot of leaves that are being requested because of the school situation. And, there's a million out there because no district is alike, or, there's one parent at home, or, there's a million stories we could probably touch on. So that's our biggest to do here. But our biggest thing is getting as much information as you can from the employee and, just seeking out that information and before you grant it, because like I said, we're still trying to run a business and that's what we're here for. So it gets sticky in a lot of places because there's, there's blended families and there's, there's so many different aspects of this whole thing and how you can grant it and what's a yes and what's a no and still being sensitive, but also, having to follow the policies and procedures. And so it's a big to-do.
Right.
Absolutely.
Are you having your employees fill out like a form when they make these requests? I know that some employers are doing that. I think that's probably one of the easiest ways to do it, but.
Absolutely. Actually, I have one right here. So we ask for, typical employee name, start date, end dates, and why you're requesting a leave, if it's a continuous or an intermittent. And there's some healthcare information we ask for. So if you are on, quarantining for some certain reason or another, and then childcare information. So the name, age of the child, because you have that 14-year-old restriction as well, even though I have a 15-year-old at home that I want to strangle sometimes because he's in, half remote learning himself. So I'm also touched by it at home too, and I'm sure a lot of people are, with working at home, not being able to work from home. I haven't been able to work from home, so I've been in the office, and my son has been home, so it's touched home too.
Mhm.
So yeah, those are the kind of pieces of information that we ask for from our employees.
Yeah, I think that makes sense because you can ask for documentation and you should in order to support the tax credit later. Like
Absolutely.
that's a good way of doing it. All right, well, let me see if I can get to our next slide. So the other two revisions to the regulations. The first one is the Department of Labor did agree with the court with respect to the healthcare provider to a certain extent, the definition, and it narrowed it. So we no longer can exclude every individual who works for a healthcare facility from the paid leave requirements of this act. Rather, the definition has been limited to employees who are healthcare providers under FMLA definition, which is basically nurses, doctors, those who are licensed medical professionals. The DOL did say that other employees who are employed to provide diagnostic, preventative, or treatment services or other services that are integrated with and necessary to the provision of patient care may also be excluded. And some of those may include nurses, nurse assistants, medical technicians. It can also include individuals who assist with taking or processing laboratory samples or performing x-rays, transporting patients or transporting laboratory samples. Now the purpose behind this exemption is the Department of Labor said that, we recognize that employees may need paid leave for all of the reasons that are in the act, but we also want to make sure our healthcare facilities are able to run to address the pandemic. So we don't want everyone taking time off. So there's that balance there. And so the Department of Labor really asks that employers of healthcare providers be judicious with how they decide to exclude them from paid leave requirements, because we do want our healthcare facilities to be able to continue to run to address the pandemic. But on the other hand, we want to prevent the coronavirus from spreading within the facility. And finally, the final thing that it did was it clarified the timeline for when an employee must provide notice of need for leave and supporting documentation. It used to say that we had to provide it before we took leave. Now it says that the documentation should be provided as soon as practical. So and within reason. So if if an employee knows that their school is going to be on a hybrid model, weeks in advance, they should be able to ask for that and provide the documentation ahead of time. If an employee finds out the night before that their school is closing the next day, they probably can only provide notice at that time. So that's sort of the thinking behind that. So that takes care of the Families First Coronavirus Act update. I don't know if anyone has any questions about that before we move on to our next topic. We can take questions now. Otherwise, I'm going to hand it off to Alan, who's going to get started with some of our executive order issues. Hearing none, I think, Alan, do you want to take over? I will continue with doing the slides. You just tell me when you want me to move.
Certainly. Go to the first slide. Sorry, the next slide. Okay, so one of the interesting Connecticut updates came by way of an executive order by Governor Ned Lamont. Sarah, can we go to the next slide? And this executive order pretty much establishes a rebuttable presumption that individuals who contracted or died from or passed away from COVID-19 within a particular period of time can have that attributed to the workplace. And let me just explain a little bit by way of background, the workers' compensation law. So workers' compensation provides benefits for death, injury, or occupational illness arising out of and in the course of employment. And these are injuries or death originating while the employee was engaged in the line of the employee's duty in the business affairs of the employer, was upon the employer's premises, or was engaged elsewhere. Generally, employees who contract illnesses must show some connection to the work or the workplace to qualify for workers' compensation benefits. Usually, this is difficult for the employee to provide for highly contagious community spread diseases like COVID-19, contrasted with healthcare style professions. So the benefits for workers' compensation include, as you may know, medical care for the illness or injury, protection against income loss when the person cannot work because they were injured or because they're ill, and survivor benefits if there's death. One important and key part of workers' compensation is it has a sole and exclusive remedy provision. And it states that benefits are provided without regard to fault or negligence on part of the employer or the employee. In exchange for these workers' compensation benefits, employees cannot sue employers to gain anything more than what's provided in the Act. So that's why workers' compensation is the sole and exclusive remedy for work-related illness, injury, or death. In terms of how this is funded, of course, you all may know that most employers are covered by full insurance, and under that, the insurance company processes and defends workers' compensation claims. However, a small minority of employees choose to self-insure themselves for workers' compensation. In addition to that, the Workers' Compensation Act has a non-discrimination and non-retaliation provision, and it states that employers may not terminate or discriminate in any way against an employee who files a claim or exercises their rights under the Workers' Compensation Act. An employee can either choose to pursue this claim in court or before the Workers' Compensation Commission. In terms of remedies, they can seek back pay, reinstatement, and benefits and attorney's fees in either form, but can seek punitive damages in the courts. So that's just a background on workers' compensation and how that works. So Governor Ned Lamont's executive order was issued on July 24, 2020, and briefly, the executive order creates a rebuttable presumption that certain workers who missed at least one day of work between March 10, 2020 and May 20, 2020 due to COVID-19 contracted COVID on the job. So the date of injury triggering benefits is the date between 3/10 and 5/20 on which the employee was first unable to work due to COVID-19 or died due to COVID-19, whichever of those two dates occurred first. For this presumption to apply, the following criteria must be met. The employee must have worked outside of home at least one of the 14 days immediately preceding the date of injury or illness without ability or instruction to work from home instead. If the date or injury occurred on 4/17, for example, 14 days after the state was shut down on March 23rd, the employee was employed by an employer or in a job deemed essential by the DECD under Executive Order 7H, and thus was exempted from the shutdown. Contracted of COVID was confirmed by a positive lab test or diagnosed and documented by a medical doctor, physician's assistant, advanced practice registered nurse, or advanced practice registered nurse within 3 weeks of illness, and the copy of the positive test or written diagnosis is provided to the employer or insurer. So that's what they must do to establish the presumption. If they meet all four of those criteria, they're good. However, it's a rebuttable presumption, meaning that the presumption may only be rebutted if the employer or insurer demonstrates to the Workers' Compensation Commission that employment was not the cause of contracting the disease. The standard for this is a preponderance of the evidence. That is a fancy legal term for more than 50%. There, the employer or the insurer would have to prove that more than 50% or more than likely than not, the employee did not contract it through work. There's actually no guidance yet on what documentation or evidence will be necessary to meet the standard. So that's in some ways difficult, but in other ways it provides employers or insurance companies with a bit of flexibility as to what documentation they can prove. So to kind of put all of this simply, the bottom line for employers is that the Workers' Compensation Commission will deem that all employees who became ill or died from COVID-19 between March 10th and April 7 contracted the illness while at work and therefore are entitled to benefits. For those who became ill between 4/7 and 5/20, only those essential workers who were required to work in person will be entitled to the presumption. Factors that may reduce risks are the employer required or allowed employees to work from home, and the employer provided emergency paid sick leave to employees. Employers and insurers will have the opportunity to rebut this presumption, but practically it just may prove to be difficult. The executive order is leaving open what kind of evidence will be needed to meet the burden. So there may be some flexibility or there may be some rigidity. We just don't know. But possible examples of evidence that may help rebut this presumption are evidence that the employee was not working on the site in the 14 days before the illness, or proof that a family member contracted the virus. So in a nutshell, this executive order was a little bit worrisome when it first came out, but it applies to more so a narrow window of time. So I think if anyone were to have this issue in the workplace, it would have likely come up already. And with that, I would ask Jessica, have you dealt with any issues of this in workers' compensation related to COVID-19?
I will say not yet. And actually a question for you, is there a time period for them to be able to file this workers' comp claim?
There is a statute of limitations to file claims. I don't know quite that it is passed yet, but I would think to a certain degree, an employer is going to be able to measure whether or not they're going to have a potential claim by whether or not they've had any employees who were affected by COVID-19 during that period.
Okay. Because I can say there may be in the future, because we've had a few positive cases in that time frame, but it has not come up yet.
So one of the good things with this is that also the workers' compensation law is an exclusive remedy. So to the extent that you're insured and the insurance company is going to handle it, that'll be the form in which it's addressed.
Okay.
And that's usually a pretty routine program and it benefits administration for employees.
Yep.
I mean, for employers.
Yep. So knock on wood, not yet.
I think that's what everyone's going to be doing here. So, we're not yet that far beyond, the farthest bound of these claims. So I think what employers should really do is potentially expect an influx of claims if you haven't already, but just simply to answer a lot of these questions, review your insurance coverage, speak with your carrier or broker, be prepared to provide notice of claims and any and all related documentation to the carrier immediately, investigate claims for support or rebuttal, and, expect premium rates to increase if there are significant issues with this. And with that, I'll turn it back over to you, Sarah.
Sure. And I guess before we change topics, if anyone has any questions on that too, we can, I'm sure Alan is happy to address them. We can do them later. The next thing we just wanted to talk briefly about was the Connecticut travel advisory. I'm sure many of you are familiar with it. And this is an example of the current map. The green states and are the ones that's okay to go to, and the red are that the travel advisory applies to. Although I think I heard that Rhode Island was just added to it yesterday. I don't see that on the map. So that's a big change and affects a lot of employers in Connecticut. So with that, I'll just get into some of the general rules that I'm sure most of you are pretty familiar with. As you know, it applies to any traveler who spent 24 hours or more in an affected state or affected country now. It's been revised to include affected countries within the 14 days of arrival in Connecticut. And it excludes stays in Connecticut that are less than 24 hours. And so upon arrival from an affected state or affected country, a traveler must submit a travel health form, and these can be found online and done online. It's recommended that you fill out the form before arriving back in Connecticut or the day that you actually arrive, no later than. And you must self-quarantine for a 14-day period from the date of last contact with the affected state or country. And now there's one new exception that I'll get to in the next slide. But I just want to let you know that, if you go to this website here, you can always find out which states are on the affected state list, and the CDC has the list of affected countries. That's what we're basing, the state of Connecticut's basing it off of. And currently it's almost the entire world that's an affected country right now. So originally there was no real exemption from this quarantine. And now it's just recently been revised in executive order. If you see 9B and 9C in early September, you can be exempt from the self-quarantine requirement if you've had a test for COVID-19 in the 72 hours prior to arrival or any time following arrival in Connecticut. And I put in brackets a question mark as to any time following arrival in Connecticut, just because there were 2 executive orders issued on this. The first one didn't have the or any time following arrival in Connecticut. The second one now does, but it's really not clear which one is the right one to look to in terms of this specific issue. I think it makes sense that you can get a test after arriving in Connecticut logically. So I think that's okay, but I know there's been some disagreement in our firm as to whether that's actually accurate. So just keep that in mind. The person has to have a result of a negative test and submit written proof of that negative test to the Commissioner of Public Health or his or her designee. Now, the state has said they will not accept rapid tests. So a negative through a rapid test will not satisfy this exemption. You have to go through and get the, I forget, they call it like a nucleic acid, the test that takes a little longer to get results back. And you must quarantine in Connecticut while waiting for the test results. So while in many ways this is welcome news for people who are traveling from an affected state or country back to Connecticut or to Connecticut, that they can get a test result, they still may have to wait quite some time. I know people who've recently taken tests and it still can take up to 7 days to get a test result back. And during that period of time, you do have to quarantine while you're waiting. There is a very narrow exception too for essential travel, which is just described here. It applies to a very narrow field of individuals who are traveling due to work in a critical infrastructure. And that includes students exempt in healthcare professions, and that such travel is related to work in Connecticut. It can't be for any sort of leisure activity. So what does this mean for employers? I think, with the exemption now where you can get a test, it's less burdensome, because you had the question of what do you do if an employee voluntarily travels to an affected state or country, there's a vacation that they planned, and now they're required to quarantine when they return. Do you have to give them paid time off? Can they work from home? Do they have to come, they can't come into work if they have to quarantine. So these are some questions that we've been grappling with. And so I think one of the easy answers to it is if they can telework. If they can telework upon return, then maybe it's not a problem. They can work from home. But it's a harder issue if an employee cannot telework and must quarantine. And then the question becomes, going back to our Family First Coronavirus Act, is now do we have to give them paid leave because they are subject to an isolation or quarantine order? And I think the answer is probably yes, if they meet the other eligibility requirements. If they have to quarantine because of this travel advisory, you may have to give them time off under the paid sick leave portion. So what are some things that employers can consider doing? I think it's important to communicate with employees about the order, maybe request more information about travel plans, where they're going. Are they going to an affected state or country? Do you maybe want to reevaluate prior approved requests or deny requests if someone is going to a country or state that's on the list? And then what do you do if an employee goes anyway when you've denied the request? So you may want to consider consequences of traveling on approved leave, discipline, no pay, but then you also have to keep in mind you can't be interfering with paid leave under the Family First Coronavirus Response Act. So these are just all some challenging issues. And again, because now we have the ability to exempt ourselves if we get a negative test, this may have less of an impact, but you do have to possibly quarantine if it takes a while to get your test results back. And obviously if you get a positive test back, you'll have to quarantine. I thought, Jessica, have you been dealing with any of these issues over the summer in particular?
All of the above.
Have you done anything effective in dealing with that?
No, like you said, you know, you can't really interfere with the FFCRA, and it's a state mandated thing to, you know, have to self quarantine. So we have been approving quite a few of those.
Right.
Right.
Right. Have you questioned employees about where they're going and maybe thought about denying?
Oh,
vacation requests?
absolutely. Yeah. Yeah. As soon as they know they are going to be leaving the state, actually, we have screeners that screen each one of our employees in the morning, and one of the questions are, did you leave the state? So you know, we ask them for full, you know, advance if they can. And we've been asking for boarding passes or any type of proof that they can provide us. So, and like you said, there, you know, even though they could be traveling to a red state, and we'll let them know, there's some people that still, you know, go. So
Right.
it's a tricky
Very
situation.
tricky.
Yeah.
All right. I think that brings us to our next. Yes, I'm going to turn over now to Alan, who's going to discuss some of the revised orders on masks and face coverings, and he'll take it to the close of this part of the presentation.
Thank you, Sarah. So there's, of course, an executive order on masks and face coverings. Any person in a public place, whether indoor or outdoor, who does not maintain 6 feet of social distance must wear a mask or face cloth covering. Individual is not required to wear a mask or face covering if doing so is contrary to the health or safety because of a medical condition, but only if the person provides the appropriate documentation. So what medical documentation is permissible? Under the executive order, the person who declines to wear the mask must have a written note, pretty much documentation that the person is qualified for the exemption under this law from a licensed medical provider, someone from the department, someone who is licensed by the Department of Developmental Services that provides support for people with emotional, intellectual, physical disabilities, or a person authorized by such agency. And the document pretty much just has to state that the person cannot wear a mask. It doesn't have to identify the medical reason for which they don't wear the mask. So that's just an important thing to know. It doesn't have to say, you know, this person suffers from chronic emphysema or something that prevents them from, you know, breathing properly. It just has to state, it just has to be from one of those individuals and state that they're unable to wear the mask. Can we go to the next slide, Sarah? Executive order on fines. Where employee fails to wear a required mask at work, the employer is liable for a $100 fine. Further, any business entity who organizes, hosts, or sponsors gatherings that violate the gathering size restrictions shall be fined $500. Currently, gatherings of 25 people are allowed indoors, and 100-person gatherings are allowed outdoors. So that's pretty simple and straightforward, but the employer would be on the hook for the fine. You know, I would think that this would come up in certain contexts where people might report employees. So I would think maybe the restaurant context and other places, or maybe you might get an employee that reports that other employees aren't wearing masks, but I think that that would be the way that the state would find out, and ultimately a fine would be issued. Can we go to the next slide, Sarah? Other miscellaneous updates, the Connecticut minimum wage has increased. As of 9/1/2020, it is now $12 an hour. There's a 10/20 sub-minimum wage for minors. There's been no change to the tip credit. It's $6.38 for waiters and $8.23 for bartenders. And there's no plans for the state to delay this. As you may know, the law states that the state can pause the minimum wage increases if there are, you know, 2 quarters of negative growth. However, there have been no plans to do this. And what I'd also like to highlight is the minimum wage over the next 3 years is going to go at a graduated rate of $1 up to $15. But we're very used to our laws going in effect in Connecticut on October 1, but each year it moves up by a month. So the minimum wage went up to $12 on 9/1/2020. It'll go up to $13 on 8/1/2021, $14 on 7/1/2022, and upwards to $15. So it goes up by a month each year. So I just want everyone to be sure that you don't want to run into wage and hour issues to the extent that you're paying the minimum wage to any of your employees. One thing that's really important is The deadline to provide sexual harassment training to your employees was originally October 1, 2020 of this year. However, the Connecticut Commission on Human Rights and Opportunities has issued an extension, and it was going to issue fines if you had not trained your employees, but now the deadline is moved to January 1. So you have an extra few months to get your employees trained. And that's a big and monumental shift. In addition, employers need to start thinking about Connecticut paid FMLA if you're not doing so already. As you know, that there was sweeping legislation passed last year. There's now a new paid FMLA program. The benefits are going to be available on January 1, 2022. And they'll be funded entirely by employee payroll tax contributions. However, contributions are scheduled to begin on 1/1/2021. There's been sort of radio silence from the state, except for this. You know, they had to, in the years leading up to paid FMLA, establish a board, create the commission. I think the board is now finally seated, if not primarily seated. There's an executive director, but there's been no guidance yet and not much else. But employers need to be aware that they have to start the payroll deduction beginning in January. And the goal there is, in order to fund the program on January 1 of 2022, you're going to need some money. So employers are going to have to start the payroll deduction for their employees. So employers must prepare to begin the withholding in January and prepare to communicate to employees in the fourth quarter so that they're aware of it. I think employees are going to be very happy to know that there's paid FMLA once it actually starts. But when they have these deductions from their check in January, they're going to wonder why. And particularly, why am I paying for something that I can't take advantage of now? So I think in the spirit of preparing your employees, it's just good to go ahead and do that next quarter so that they're aware of it once it happens. Employers may register for the withholding and those requirements as of November 20 of this year. I encourage everyone to take a look at the ConnecticutPaidLeave.org website. That actually is launched in the past week, but it contains several helpful items, and I think will continue to provide helpful content over the next year as employers prepare to administer this program. And the last thing is the extension of unemployment benefits. Recall under the CARES Act, it provided for a supplemental unemployment compensation payment of $600 a week. In Connecticut, of course, the state max is $649, but this meant there was a maximum total of $1,249 a week being paid to unemployed employees, but that expired at the end of July. In a new executive memo by our president, he added a $400 supplement to replace the expired $600 supplement, and that would begin retroactive to August 1. The mechanics are states can elect to participate or not. If yes, they must pay 1/4 of the $400. So $300 will come from FEMA and $100 from the state. States can use the funds received from the Coronavirus Relief Fund to pay for the state share. And to participate, the state must request funding from FEMA and agree to administer and oversee distribution, and of course, agree to pay their 1/4 share. Connecticut has elected to use the additional $300 from FEMA. However, it could run out of support soon though. And really the point there is don't know really how long it's going to last. And it may only cover individuals through halfway through August, but there's at least some funding there for now. Yeah, and with that, does anyone have any questions about the miscellaneous updates?
Ellen, I'll throw out with the, obviously everyone's been waiting on Congress to come up with a compromise, and we won't know the details if they ever do, but would you expect something like that would be potentially backdated, going all the way back to fill in where the president's order had been?
So I think in these uncertain times, it's really hard to tell what Congress is going to do or what they're going to prioritize in the next 43 days. All I can really say is it'll probably be something in the realm of possibility or to be discussed. But, at this point, we have, no new law at this point, and not really sure when we'll, get a new one and what it'll include.
I think there was a question on FMLA too, and just that that applies to all employers, or do we have the minimums of like 50 employees? That was part of the original proposal, but if I'm correct, it's all employers, right?
The paid FMLA, or is that?
Yeah.
Yeah, it's any employer with one or more employees applies to.
Other questions out there?
Related to the FMLA, but there was a state mandated retirement fund, which is also going to be an employee paid benefit. What's the status of that? I know they were having trouble seating a board on that, and is it going forward?
I'm not sure about that one.
I think that's the one that I think it dissolved. It may still exist in the law, but I feel like that I may be getting the story wrong. But this was about a year ago, and the board, the state wouldn't give them any more subsidy money, so they let go of the executive director,
Right.
and didn't move forward. So I know it's Charles. It was still sitting there on the books, so it wasn't something that they could turn back to. But I don't believe that they've moved any forward at all from that where they were.
Yeah, because it is on the books. Thank you.
And Sarah, one on the quarantine, I do think it's the second executive order on that you can get the test once you're here, because I know a big driving factor in the change in the executive order was the airport authority, who felt like Bradley was really suffering. So they were lobbying a lot, the state, to make sure that people could arrive and then get tested.
Yeah, I think you're right. And I tend to think that it makes most sense that you can get it once you come back. Yeah.
Other questions? Jessica, any other things out there that have come up over at Ops and Motzker that you guys have been dealing with?
No, I think we touched upon everything today, from, travel and FFCRA, and how each person really has their own unique story on, why they need to leave and how they need to leave, and how you need to, again, be sensitive to it, but still, try to, get these machines rolling too. So.
And I know you've been doing this for over 6 months now, but you mentioned having screeners. So is that process of being able to screen the employees and just even the people who have to stand there and be the screeners, has that all worked well?
Absolutely. We've had quite a few people that we've had to turn away for some sort of symptom, or, they were truthful about the screening questions. So I think it's worked very well for us.
Great. Well, Sarah, Alan, Jessica, thank you so much. We appreciate you doing this, and a lot of really good information. We're going to do our breakout rooms now. We have about 10 minutes to do that. So it's all randomized, and I think we'll break up into about 3 rooms, and I'll let Tamika do that. So in the next moment, we'll disappear everyone into the breakout rooms. If we don't see you on the back end, thank you again so much for joining us. Thank you to Carmody for sponsoring our HR Council, and also Mosaic with our Nonprofit Resource Council. And with that, we'll see you guys in a few minutes. I got his voicemail. I just left a message for him. All right. Let's see.
I think everyone's in the room except for Richard.
And then you can see the room, so you can see if we need to
Yeah.
move anyone.
Yep. looks pretty okay because I can see Glenn, I can see, oh, Heather and Jennifer, there's only 2 people in there.
Only 2 people?
Yeah, because it has you would have gone there, but you haven't joined, and Richard would have gone there, and he didn't join. But all the other rooms are fine.
You can move them to one of the other rooms if you want.
Okay. Oh, how do I do that?
Click on them.
Okay. Move 2. All right, here we go. I'll move them to 1. And I'll move Jennifer. Okay. All right, good.
And I think Jen Fournier joined too. So you...
Yep, I moved her.
Oh, okay.
So now we're good. We've got a nice, yep. We've got 1, we've got breakout 3, we've got breakout 4, and we've got breakout 5. And Jesse is now in 1. Perfect, good. And I know we started a little later than we thought with the breakout rooms. So it says here I can send a broadcast message to everyone. Do you want me to just tell them that we'll bring them back for final announcements, or you want it just to fizzle out?
I think we'll let them. What's the best way to do this? I mean, maybe it's good to give it an end time because otherwise, people might just linger on there.
Mm-hmm.
And kind of slowly, so
maybe in another 4 minutes, like 8:57, I'll send this message. We're bringing everyone back for final announcements.
yeah, I mean, you could even do it just do it right at 9 o'clock. Just bring it,
Okay.
just do the thing. And...
So that's closing all rooms, and then that brings them back automatically?
Yep.
Okay.
Yeah, your process was slow. They've been,
Oh, yeah.
holding out on you.
They just kept saying that I was one of several that were 180 days, 200 days in the process. So I don't know what was going on, but They did say people were leaving the company, and I don't know. There must have been just internal strife.
Oh, so they started apologizing to you?
Oh, from the very beginning, they said, "Oh yeah, your process." He said, after I kept asking, he was like, "Oh yeah, we have people in the process who've been here 100 and something days." I was like, "What?"
That's crazy. Yeah, I mean, it's one thing for if you were buying a new house, but for refinancing a house.
Yeah, it was so bizarre. And I kept saying, every time I kept thinking, okay, I'm going to just get out of this and go to another company. Um, then I would progress. So they would ask me for one more thing and one more thing. So then I finally said, you know what? I'll just ride the wave.
Oh yeah, no, I know. Yeah, too far deep in. Yeah, we went through Loan Depot, which I was a little suspicious of going with one of these online mortgage lenders.
Yeah, I'm always nervous about that. So that was okay.
Yeah, it was fine.
Loan Depot. I've never even heard of that one.
It was fine.
You just happened to look that up online, or was that recommended to you?
No, just it was the best offer we got online.
Wow. Yeah, I was just so excited about the opportunity because I'm going to be saving $400 per month. So I was like, whoa, gotta do it. Gotta do it.
Oh my gosh. Wow, what was your rate before?
Well, I had an arm.
Oh,
So my arm expired. Then what happened? Then I couldn't refinance because of something. Oh, because I was in between, I was in transition. So I couldn't demonstrate that I had steady income.
yep.
And so I had to wait.
Gotcha.
Mm-hmm.
Oh, that's a really good savings then.
Oh yeah. That's why I'm like, saying, hey, I mean, what's the problem? Why, everything's impeccable. And every time they asked me for something, I would send it right away, right away. And then they kept saying, oh, well, it's still in underwriting because the person hasn't looked at it. And then that's when I lost it. I said, what do you mean they haven't even looked at it? Because they would have so many more loans ahead of me. They would be backed up.
Yeah.
So they would say they were going to look at it. They would tell me to submit all this stuff, and then they wouldn't look at it, and things would start to expire according to my processor, and I'd have to resubmit documents. They even had to do another certification of my home appraisal too. And I'm thinking, oh my God, what are you talking about? He says, oh, don't worry, you don't have to do anything. We just have to do something behind the scenes. So I was like, okay. So yeah, I wish I had never started with Citibank, but it is what it is. They had a great rate. They sucked me in, and now it is what it is.
All right. 9 o'clock.
No, 8:59, almost. I just sent them a message saying that, 2 minutes will bring them, well, 1 minute will bring them back. To give them a heads up.
Sounds good.
So you being not in the room, you can't see anything that they're seeing, obviously.
I did actually see that message. Just kidding.
Oh, okay. Yeah, this is my first time doing this. This is kind of cool. I feel like I'm the Wizard of Oz, behind the curtain.
I got all the controls.
All the controls. Except I'm not a short little man. Okay, closing all the rooms.
Can you share screen?
Share screen. Yep. And I'll go back to, we have real estate to announce.
Okay.
we're just going to leave the meeting now. We're done, Tamika?
We're just gonna, one last announcement and then we'll let everyone
Oh,
speak.
okay.
But if you have to go, don't feel like you gotta wait.
All right, and hopefully you can see my screen.
Yep. Great. Well, thank you everyone again. It was a great panel. I hope that you guys had good conversations in the breakout room. We just want to remind everyone tomorrow we have our regional real estate and construction forecast. Still time to sign up. Again, that's an online event for tomorrow. You can go to our website for more information. Hope everyone has a great day and thank you again.
Thank you.
Great program. Thanks very much.
Thanks.
Thank you. Good to see you again, Paul.
As well. Not tomorrow morning, though.
Yeah, probably not.
Thanks, Alan.
Tamika. Yeah, bye now.
You're very welcome. Thank you all.